Hi, y'all, and welcome to tonight's live stream. Well, it's here. We are actually supposed to begin the trial of Donna Adelson tomorrow with opening statements beginning tomorrow. And we will be doing live gavel to gavel coverage right here on the channel. Please join us. It's going to be wild. We, of course, covered Charlie Adelson's trial. That's Donna's son. They are both jointly accused of conspiring together and with other people to murder Dan Markel, a Tallahassee law professor. And they are accused of doing that because Donna wanted to spend more time with her grandkids. Dan Markel was her ex-son-in-law. And according to the state, Donna felt like he was getting in the way of her getting together with her grandkids and even having them move down to Tallahassee. So tomorrow, at long last, we will be looking at the opening statements. Right now, 110 jurors have been selected as, not selected yet, they've gotten through. They've gotten through the gauntlet of how much they know about the case and some individual questioning. And now there's going to be further discussion. There will be more motions by the attorneys from both sides about particular jurors who ought to be removed from the pool, and then they will both be allowed to select the jury. So tonight, what I want to talk about is, in general, what's been happening, what's going on. I want to talk about one really good argument that Donna Adelson is making about jurors, and I want to explain it to you. These are her arguments about why certain jurors should not be allowed, and I want to talk to you about the law and why it is working out this way. And then the third thing we're going to talk about is how Donna Adelson is dressed. And no, it's not frivolous. It's not simply idle chitter chat about what she's wearing. It really actually makes a difference, or can potentially make a difference in the trial. So hang on. We are in for a wild ride tonight. So as I said, I'm going to be live streaming tomorrow. As soon as opening statements start, we're going to be going live with opening statements. We really would love for you to join us tomorrow night. I also want to say before we get started, this is Make a Will Month, and I will say you need a will. We have an affiliate link down below in the description. If you would click that, I would appreciate it. It takes you to LegalZoom and it helps you make a will. I did it for my dad. I've been putting it off for absolutely forever. And instead, I found it was unbelievably easy. Nothing to it. It took less than half an hour, and they sent beautifully formatted documents, and we took them over to UPS and got them notarized for $12. And bam, huge task off my list. So, all right. We started the day, or not the day, we started each set of jury interrogations, I guess you'd call it interviews. We started that with reading a statement about the case. The judge said, here's an agreed upon statement about the case. And he said, look, and tell you what, it was really brief. It was basically Dan Markel was shot while seated in his car in his driveway. The killers traveled to Tallahassee in a green rented Prius. I thought that was pretty specific. The defendant is Dan Markel's mother-in-law. She has entered a plea of not guilty. All of that merely informs you of the accusation, and it doesn't mean that there's anything specific about her being guilty. So then they called in the jurors. They initially started in groups of 50, and they took them in for individual questioning. And I wanted to go through a little bit about what the judge told them before he started the individual questioning. It wasn't much, but I think it'll tell you a lot. Let's get started with that.
In count one, that on or about July 18, 2014, Donna S. Adelson in the county, Leon, and state of Florida did unlawfully kill a human being, Daniel Markel, by shooting with a firearm, and the killing was perpetrated from or with a premeditated design or intent to effect the death of Daniel Markel, contrary to the Florida statutes. Count two. Beginning in 2013 and until October 1st of 2016, Donna S. Adelson in the county of Leon and state of Florida did agree, conspire, combine, or confederate with Charles Adelson and or Catherine McBanois and or other persons to commit first-degree murder, contrary to the Florida statutes. Count three. It is alleged that beginning in 2013 and until October 1st of 2016, Donna S. Adelson in the county of Leon and state of Florida did solicit another to commit first-degree murder, and in the course of such solicitation, commanded, encouraged, hired, or requested the person, Charles Adelson and or Catherine McBanois, and or other persons to engage in specific conduct which would constitute first-degree murder, which resulted in the death of Daniel Markel, contrary to the Florida statutes.
Now, what's really interesting about what you just heard right there is what's not there. It's pretty much what we would expect and what we did expect from the beginning of the case. She's charged with murder, she's charged with conspiring to murder, and she's charged with solicitation to murder. But it's the people it's with, which is Charlie Adelson, her son, and Katie McBanois, Charlie's girlfriend, who is alleged and now has acknowledged hiring two hitmen to carry out the murder of Dan Markel, not Wendi Adelson. Now, what's also interesting about that, and as we know, Wendi is Donna's daughter, has never been charged in this case, but has often been discussed as a potential co-conspirator, as a potential person who could have been involved. In fact, the state has called her a co-conspirator at times, but she's not named in this. And then also, what's really interesting about this is that it completely does not discuss new charges related to the investigation into whether or not Donna was tampering with evidence by trying to get witnesses to falsify evidence for her. We've heard about that. It's been fought about under seal with very little information leaking out to us for months now, but there's no new charge related to that. So the defense has said there's no evidence of it at all. Is the state dropping it entirely? It doesn't seem like it. I say that because there are witnesses around this. There are witnesses who are still on the exhibit list. These are inmates who served with Donna Adelson in jail. And it certainly seems like the plan is for them to testify. So at this point, the judge has not ruled that out, but it doesn't appear to be anything that is the basis for a new charge. The idea that Donna Adelson would try to persuade people to testify for her, to fabricate evidence, it may be that the state plans to talk about that more in the context of this shows her consciousness of guilt, that she felt like she needed this. It may be that that's how they plan to do it, but there's nothing about them using it as a charge against Donna Adelson. So that's pretty important in what we just learned about there. The judge also talked about what he was going to ask the jurors when they got to individual voir dire, that there would be specific questions that they would be asked about. And here's what he said they would be asked.
Number one, what do you know about this case? Number two, what sources have you obtained this knowledge from? Number three, based on what you know, do you have an opinion about Mrs. Adelson's guilt or innocence? Number four, can you set aside your present knowledge, disregard it, and render a verdict solely on the evidence presented in the courtroom? Can you be fair and impartial? Number five, do you have any reason that you cannot serve on this jury for potentially up to 3 weeks? After that process is complete, we expect the trial to start on Friday and potentially go for 2 weeks after that. All in total, we expect the proceedings from today may take up to 3 weeks. We understand that is a burden for anyone to serve for that length of time. However, we cannot make our system of justice work unless we have good people that are willing to do their civic duty as jurors.
So what you hear right there is a list of things related to what the jurors might already know about the case. It's obviously been heavily publicized. I mean, we've been talking about it on YouTube for years, right? But not everyone in Tallahassee is going to know about it. And what the judge is saying is, I'm going to ask you, what do you know already about this case? And is it going to get in the way of your being fair, of your being impartial, so that Ms. Adelson can receive a fair trial? That's what we're going to be talking about inside the individual voir dire. That plus the question of whether 3 weeks would be impossible for you to do. Is that going to present a real hardship for you? So around that issue, there's something really important I want you to know about the law around the issue of picking fair and impartial jurors. I personally don't think that this is fair. We're going to get into it. We're going to talk about it. It won't be too technical, I promise. But I want to start by thinking about what is Donna Adelson's ideal juror and what she thinks her ideal juror is. She believes her ideal juror is someone who is not from Tallahassee. She has moved over and over again for a change of venue. It's been denied. It will be denied again tomorrow, I think rather handily. I think she'll raise it again. I think it will be denied. But at this point, we have unusual insight into why she thinks Tallahassee would be unfair and into what makes her think that. The reason we have that is that she was recorded on phone calls with her son, Charlie, who was convicted, and therefore all calls to him in jail were recorded. Those recorded lines show them talking about what happened in Charlie's trial and how they believed he didn't get a fair trial because of where it was. I don't think they're right about that. I think it was something other than where it was. But I do think they have, or at least Donna has, one important point under the law. Let me say, first of all, welcome to Sonata, who's a brand new member. And thank you, Jackie, for gifting 5 Lawyer Lee memberships. Our mods will tell you how to turn on the ability to receive a gifted membership, or you can always hit join down by the name Lawyer Lee right below the video. Thank you again, Jackie. Veronica has a question. I'll save that for the end. Mildred is trying to picture the 2 hitmen driving a Prius. That would be something to have seen, I suppose. And thank you, Mildred. Just Mildred, I appreciate your comment and your super chat. And Molly has been a member for 18 months, and it's her birthday. Happy birthday, Molly. We are glad to have you with us on your birthday. So I hope you're having a great day. All right. And Mama Pinks is saying happy birthday to Molly. So happy birthday, and thank you, Mama Pinks. Mama Pinks and Marlon are our 2 mods. We are so grateful to have them here on the channel. So let's get talking about the jail phone call between Donna Adelson and her son, Charlie. Now, this is right after, the day after Charlie was convicted. And Charlie was completely floored by the decision that he would be, that he was found guilty. Had no idea. And he tells his mother that. He thought all weekend long he was getting out. This was just a matter of time. He even gave away all his food, the food that he had got from canteen or saved up. He got all of those. He gave it all away. What would he need it for? He probably wouldn't even be coming back to the jail. So, and he said to himself, you know, my attorney is an expert at closing argument. That's one of his strengths. And I'm just sure we're going to win. He concluded and told his mother that the reason they lost was Wendi's book, his sister's book, and what was implied about what it said about Tallahassee. That, and just the fact that it was in Tallahassee, it was all their fault. Let's add this back to the stage.
He was convicted my dog if they brought my dog up there.
So I would say what he says is that they would have convicted my dog if they brought my dog up there. And apparently that was not an exaggeration. We here on the Lawyer Lee channel have been able to get actual fake footage of the exact moment when Charlie Adelson's dog, what he was describing, where the city of Tallahassee actually convicted Charlie's dog. This is actual fake footage, which we have gotten in a real coup. So apparently it was not an exaggeration, as this actual fake footage will show. So yes, Charlie's dog was convicted. Bad news for Charlie's dog. By the way, would you mind hitting the like button? That'll wake YouTube up. Tell them, yes, we're out here. I would appreciate it. And also, if you aren't subscribed, be sure to do that and turn the notifications on for when we go live tomorrow with opening statements. So I say this obviously joking. Charlie's statement that they would have convicted his dog, that there was no possibility he could ever get a fair trial in Tallahassee. It's not a joke. I mean, the dog part was a joke, but it's not a joke in this sense. Charlie and Donna, as we can hear from their conversation, really believe they cannot get a fair trial in Tallahassee. They actually think that that's the case. Here, you can hear them talk about it.
Shock. Like, it's a shock going from Sunday to today. Literally, Sunday, I'm giving away all my food and, like, feeling like, you know what? Everything came in the way it should have. Dan is the expert at closing. Closing is his specialty. He's going to go in there and kick some ass. And, like, it was Wendi's book, making fun of the people of Tallahassee as a small town on the way to her big-time Miami. Like, holy...
Nonsense. It was stupid nonsense. It was just nonsense that they did.
It wasn't the case. Like, it wasn't the case. It was a Dateline special with horrible photos that would make anybody sick and angry. And then cut and paste things out of context. Like, sentences have no meaning when they don't have a context. Like, what was said before and what was said after. Otherwise, it's just words. Like, is there an explanation? You're not giving an explanation. You're just cutting and pasting words that look bad. Like, I gave an explanation. I gave context. I gave meaning to what I was saying. Like, they're sitting there. Yeah, they're sitting there going, Donna's got crazy emails. Wendi's writing a book. And what is the name of that town? Like, everyone knows you picked it. What does it have to do with anything? Because it showed that she was like, thought she was so smart and so much better than everybody else, and putting Tallahassee down as a small stop on the way to civilization. Like, she's leaving Tallahassee and she's going to Miami, and she's foreshadowing it in a book, and she's making fun of you people from Tallahassee. And look at these crazy emails. And there's code, there's a TV, there's no TV code, but TV, like, holy shit. Like, this was made for, like, a fourth grader, Dateline, 2-hour special, that with a southern accent from Tallahassee. Like, it was with your best friend, Ryan Fitzpatrick, saying this. And even his sister said this on the stand. Like, even she, who should be his biggest defender in the whole world, even she is saying this. Guys, come on, you're smart. You're smart people from Tallahassee. Just, you know what's going on here. Y'all know what's going on. Like, I turned to Kate and I go, this is not good. They would have convicted my dog if they brought my dog up there.
And we do have proof that they actually did do that in Tallahassee. So Donna agreed with Charlie. She fully agreed that the problem had been not the presentation, not the facts. The lawyer had been great. Charlie had been great on the stand. She agreed fully that it was the jury that had been the problem, the jury that had presented the problem. Let's go ahead and add this back to the stage.
What happened, Charlie, is that nothing mattered. Nothing matters. They didn't care.
It's also the way it was that. It wasn't like they were presenting facts of the case versus facts of the case. You know, they even said, like, our key witness, you don't have to believe her. Well, who the fuck else are you going to believe if you can't believe the key witness? Like, you know, witnesses, real people showing up, asking questions. So you can shoot them on the stand. No, that don't matter. Look at Donna's emails. Like, Charlie's buying his dad catering for the birthday party. Like, no, it must be something else. No, it was paella. Remember, I paid for it. Like, they're trying to pull it over on you guys. You're smart. You guys know. I mean, like, beyond a reasonable doubt should be like, for a case like this, should be like, you know what happened. Not like you hate these Miami people who think they're better than you. Right. They're arrogant. Who think they're untouchable. Who said I was arrogant or untouchable?
I know. No, I know. I heard it. You were cringing.
Like, who said I was arrogant or untouchable? How about innocent? What's up with that word? It's like if your southern accent, you're looking at the Playboy Carried on us, it was arrogant. Like, what who makes more money than you has to be arrogant. Anybody who makes more money than you from Miami who's younger than you is arrogant. Like, you guys know nothing about me. You label me as arrogant. You label me as untouchable. You label me because you're smarter than everybody else. Because you're a doctor. Like, you're dressing me up with all these fucking adjectives. And then you get all these people who probably make $35,000 a year. Look at how they are people. And they're looking at you like you're an alien. It's your southern accent. And then they're giving you emails that are horrible. Taken out of context. None of the things were ever done. It's just anybody saying, show me your.
I'm going to stop it there because it is frustrating how bad the quality.
Nothing about me. You labeled me your.
Tell you what, we'll just remove that.
Oh,
I see what happens. I was trying to find just where to stop it, and I was playing it twice, so that's really, really confusing you. No wonder the sound quality was so bad. Okay, so anyway, the sound quality is rough coming out of the jail. It's not like super fine recording, but basically what they're saying around this is, look, these jurors, Charlie is saying, well, how many of them have even read a book? They were offended because Wendi wrote a book because we were a wealthy family and they were out to get us. They were out to get us. That's how all of Tallahassee was. And I do want to make an argument on Donna's behalf here, because I do believe that fair is fair. And I do believe we have certain standards that we ought to adhere to. Even if, regardless of what we believe about whether someone's guilty or not. So I do think that she is wrong about the issue being Tallahassee. The issue isn't Tallahassee, but I think that there are some issues around jurors who know about the case, jurors who already have an opinion about the case. And there is an entirely legal, allowable thing that is normally done in cases. In Florida, it's allowed by statute. There are similar statutes all over the country. And to help you understand what I'm talking about, I want to talk a little bit, and I'll go ahead and pull this out. And I am all the way full again. Okay. So I want you to understand a little bit about what it is that jury selection involves, because the way it works is that both sides get strikes. That means they get to look at the jury pool, the veneer or venire, depending on where you practice, and they get to look at that group of people and say, I don't want this person, and I don't want that person, I don't want this person. There are some reasons they can't use, like race or gender, but there are lots of reasons they could. Don't like the way she looked at me, think she might not like me, she might have a bias, tons of reasons. I mean, you don't even have to give a reason. You just have to not have an disallowed reason. As long as you don't use one of those, you can strike absolutely anybody, but you only get 10 of those, and they are precious. You hoard them like gold as an attorney. Those are so important because you want to be able to strike every single person you think might have a bias against your client. Everybody, honestly, you want to strike anybody who wouldn't be in favor of your client. You want to keep only the people you think would be in favor of your client on the jury. That's what you want. And both sides want exactly that. So in this case, the judge is giving each side 10 strikes. There will be 12 jurors. He talked about possibility he would do just 2 alternates, decided, no, I'm going to go with 3 because he said, do you want me to go with 3? And the defense said yes. So 12 jurors, 3 alternates. That's what he's going to be going forward with as we move into trial. And in order to get there, he has to have 12 plus 3 plus 10 strikes for the prosecution plus 10 strikes for the defense. And then tomorrow, as they go through and talk about the jurors, both sides will get the chance to argue that certain jurors should be stricken by the court, not just by, like, Charlie shouldn't have to use one of his strikes, prosecution shouldn't have to use one of theirs. It's clear to everybody that this particular juror should not be allowed to sit on the jury. So that's a great way that lawyers use to get around the fact that they only have 10 strikes. If you can possibly find a really good, legitimate reason why this person should not be allowed to sit on the jury, then you can get the judge to strike that person and you can save one of your 10 strikes. During the phone call, you even heard Charlie talking about that. I'll just read it since it was our last little bit and it's not very much. He said, look, you could only make so many X's. And he was referring to Xing out a juror. That's the problem. Yeah, I mean, the X's that really need to be used, they're X's. There's someone who would give Charlie a fair shake. Get him out of here. They use in other words, he's saying, look, the way they got to use their X's was the prosecution. They got to say, oh, that juror might give Charlie a fair trial. We wouldn't want that. And so they would use their X's on that person. That's Charlie's statement. And they used their 12 to get anybody that would have given me a fair shake. That's what Charlie said on the phone call. And then he said, I use my 10 to get rid of people I needed to get rid of. Now, Charlie is actually a little confused about that because the truth is both sides. I have never been in a case where I felt like my strikes, that was all I needed. I removed absolutely everybody from the jury that I wanted to. That has never happened for me, not once. And I think that's probably true for most attorneys, that they always wish they had a few more strikes. And that's why you're talking to the judge about eliminating anybody who might have a potential problem. And you're trying to persuade the judge to do that for you. And Charlie's saying, look, I didn't have enough left over. And there is one reason that I think that that's probably true. And let's talk a little bit about the presumption of innocence. Now, it might surprise you to know, believe it or not, the presumption of innocence is not actually in the Constitution. It's certainly presumed. It's something that has through cases, through statutes, it's definitely assumed within the United States, but it's not actually in the Constitution that you have the right to the presumption of innocence when you go to trial. But there is the Fifth Amendment, which says you have the right to due process, and the Sixth Amendment that says you have the right to an impartial jury. And then there's the 14th Amendment that gives you due process and equal protection. And so recognized through those in-court decisions over and over, we have the presumption of innocence in our country. But there is a Florida statute that says something a little different from that. I want to show it. It may sound different. I want to show you why I think it's a contradiction. All right, so this is the statute on how you would challenge an individual juror for cause. What that means is this is how you would tell the judge, I don't want to use one of my strikes, Judge. I think you should eliminate this juror for cause. There's a reason why they can't serve. Some of them are really unsound mind, or has a bodily defect that renders him incapable of serving, or served on the grand jury, so they can't hear this case. They're going to be a witness. There are all kinds of things that might eliminate somebody, but I want to focus on number 10 down here. And number 10, if I could move this up any further, I would. But Connie, I'm going to have to say happy birthday to you. I'm so glad also that you are spending your birthday with us. And thank you, Mama Pinks, for your super chat. So, but I'm gonna move that off so we can talk about number 10 here. This is a juror and a reason you could strike a juror for cause. A juror has a state of mind regarding the defendant, the case, or the person alleged to have been injured by the offense charged, which would be Dan Markel, or the person on whose complaint the prosecution was instituted, which is the state here, that will prevent the juror from acting with impartiality. but the formation of an opinion or impression regarding the guilt or innocence of the defendant shall not be a sufficient ground for challenge to a juror if he or she declares and the court determines that he or she can render an impartial verdict according to the evidence. So what that's saying is, the judge can strike somebody if there's some reason that they can't be impartial, that they have formed an opinion or an impression, but that's not enough. Even if they formed an opinion or impression that about the guilt or innocence of the defendant. In other words, I already have an opinion that Donna Adelson is guilty. I think Donna Adelson is guilty. That's not enough for the judge to strike the juror for cause if the juror declares, and the court determines that that juror can render an impartial verdict. So here's what plays out in real life. This is from the Tallahassee Democrat, the local newspaper. And it talks about the fact that Judge Everett convened in chambers. He talked individually to each of the jurors. And one potential juror told Judge Everett that he had heard about the case from TV and radio and had somewhat of an opinion about Adelson's guilt or innocence. It's not favorable, the man said. Josh Zellman, one of Adelson's attorneys, asked the man if he had a strong opinion about the case. He said he did. You already think she's guilty? Zellman asked. Yes, the man said. It's my opinion as of now. However, the man said he could set that aside, hear the evidence in the case, and make an unbiased decision. Zellman asked to strike him, but Everett declined. Now, I personally don't agree with that. Let me pull that out so we can talk. So personally, in my opinion, if a juror says, I have a strong opinion that the defendant is guilty, to me, that contradicts our presumption of innocence. That is the juror coming in saying, well, this is what I think, but you can persuade me otherwise. That's the opposite of the presumption of innocence. That's the person coming in and saying, I don't think you're innocent, but hey, I'll give you a shot to persuade me. It moves the burden of proof to the defendant instead of putting it on the state. I think that's wrong. I think that that's an unfair burden to them. And furthermore, I think it's unnecessary here because there were plenty of jurors. They had more who weren't even in the pool. In my view, the judge would be better off to strike all of those so that there's no argument. I do not know that Donna Adelson preserved this well enough for purposes of appeal. It's just my opinion that if a juror comes in and says, I have an opinion about the case, I have an opinion about the guilt or innocence of the defendant, that ought to be a reason to eliminate that juror. Now, it's not. There's a statute that says what Judge Everett did is absolutely correct. I showed you the statute. That's exactly what it says. He did nothing wrong under the law. I just don't agree with that. I think that there should be a challenge to that. To me, that's not fair. I don't think that's the way jurors ought to be picked. I think they ought to be picked as people who don't already have an opinion about the case and are willing to wait and hear what's said in the courtroom, what the evidence says, what the witnesses say. So that's my particular view on that. So they have plenty of jurors and just skip that one, have the judge strike that juror. And maybe he will, maybe in the end he will. I don't know how many there were like that. If there weren't that many, he may have written it down and said, okay, but there were 4 like that. We're going to mark them all out. That still could happen. So, okay, last thing I want to talk about is real quickly, I want to talk about Donna Adelson's appearance. Now, and I do not think this is frivolous. It's not just, let's talk about what was she wearing. It's not like that at all. This is really serious. Lawyers do a lot of thinking and talking about what clients should wear, about what they should wear. I have a friend who received some really heavy duty work with a jury consultant who advised her that she needed to wear light pastel colors in the courtroom. This is an attorney. And that jurors would see her as more relatable. They would really want to talk to her and be involved with her if she was wearing light pastel colors. I've always thought that was really interesting. And it's something lawyers think about. I worked with a guy who was convinced that the way he dressed was the first day of trial, he would wear a blue shirt. Well, that's so odd, right? You know, lawyers are always wearing a white shirt, red tie. and a dark suit, right? Especially the guys, that's what they're always wearing. So he would wear a blue shirt. And he said then the next day, the lawyer from the other side would follow suit. It's like, oh man, he wore a blue suit. He's going to be more relatable. I'm sorry, blue shirt. So he would the lawyer for the other side would then wear a blue shirt the next day. But on that day, and it was usually maybe opening arguments or maybe second day of jury selection, the guy I worked for would wear a crisp white shirt with a red tie. And he just felt like that kind of threw the other side off all the time. So I'm telling you that a lot of thought goes into this. It's not just frivolous or something that is casually done. So one of the things we can see already is that with her dress, Donna Adelson's team is sort of leaning into the old grandmother look. I have a couple of pictures for you that were taken by this one actually came from the video feed. This is what Donna Adelson was wearing. I believe this is today. She had the purple shirt and a dark cardigan, probably black, maybe navy blue. I like the cardigan look. I think that's very grandmother-y, and I think it's a good look in general. I'm not crazy about the purple. Here's a little bit further back. You can see Donna is on the left. Her attorney is on the right. A lot of people are saying they look alike. I think they look pretty different, but that's just me. And Donna, you can see wearing a cardigan and then a collared shirt underneath it, sort of a casual look. I think it's a real, a look that I think it's overall a pretty good look, but I do think they could soften her up a little bit. It's pretty harsh. I think the purple is a bad color for her. She's got the dark, and I totally get that this is a murder trial and they want to be careful about that. But I just want you to take a look at this, and this probably is going too far. I get it for a murder trial, but think about your perception of this person. What do you think about this person? She probably makes cookies, right? She probably bakes cookies in her kitchen with her grandkids, and she just looks more approachable. And a lot of it has to do with the softened colors, I think. And so I think that I'm curious to see what they will do. They have leaned very hard into a particular look for Donna Adelson, this older grandmother, this not wealthy at all grandmother. And I think we're not only going to see a continuation of that, but I think it heralds what we're going to hear, because we have heard from her when she's testified at hearings, sort of the idea that she is really just someone who does not have, she didn't know, she's older, maybe she forgets, she doesn't really know stuff, it's not her fault. And those sorts of, I think those sorts of arguments are going to be throughout the trial. And they may open up the possibility that Donna's son will come and say, yeah, she's not a doddering old person. She's really sharp, and she did all of this fully intentionally. But I think you can already see this is being shaped, and you can see it in what they have her wearing. What they have her wearing sort of takes you into where they're probably going to go with their arguments in the trial. So, I have a bunch more people to thank, and I have to answer a question from earlier as well. So if you would be putting questions in the chat, if you put question marks at the beginning, I have a much better chance of spotting those. My father's alibi. Thank you so much. 50 lawyerly memberships. That is awesome. Thank you so much. I really appreciate that. And so will a lot of people out there. So be sure to turn on your ability to get the gift. It's randomly done by YouTube. So hopefully you will be the one who gets that. Mickey Bassett has been a member for 18 months. That's wonderful. Just a normal person who watches Lawyerly. Well, I'm just a normal person who does Lawyerly. So I'm very glad to have you, Mickey. And yes, please don't forget to like. Did I say that? I think I did say that once, but please like again, vote early and often, like early and often. I realize you can only do it once. Okay, Chico Karen has been a member for 18 months. That's awesome. 18 months is like the entire time we've had members, so thank you both. Courtroom Confidential, gifting 5 lawyerly memberships. Thank you. I will be right after this on the Courtroom Confidential show. So when we shut down, you can head on over to Courtroom Confidential, and Josh and I will be talking more about the Donna Adelson trial, a little bit about the Koberger as well. So head on over after we finish up here, and you'll see me over there. Starting at, I think we were doing 8:15 or 8:30, I think it was. So anyway, see you soon after that. And thank you for the lawyerly memberships, Courtroom Confidential. And Teresa T is one of our new members. Thank you. I'm glad to have you. It seems it should be obvious, says Lizbeth. And I think she means probably the dressing. That's my guess as to what Lizbeth means. Thank you very much for the super chat. And I think it is something that lawyers think about a lot, but you won't have any idea that this is going on in the background, that people are talking about this and thinking about this and strategizing and planning. It's all part of a choreographed presentation by the attorneys. It's not, very little that goes on is an accident. A lot of it is fully intentional. So anyway, I just wanted to show you the idea of the softening and what it would mean in real terms to actually see that. So that was why I had the picture. Okay, so let's go over. I know we had a question earlier in the chat. This is from Veronique, and she wants to know, what do you think will be the most important elements of this trial? I am excited to be going live too. Thank you, Veronique, for talking about that. It will be, as I will be going live with the opening statements tomorrow. So I will be doing live legal analysis starting before the opening statements start. And we will be talking about the case as it goes. So come watch with me. We're going to have a really good time. I think I have never done this before. I am absolutely terrified. I haven't slept in like 3 days. I don't know what I was thinking saying I would do this, but I am really looking forward to it too. I think it'd be fun to have people to watch the trial with. So please come. Please be one of our people I can watch the trial with and talk about it with. I'm really looking forward to doing that. So to answer her question, what do I think will be the most important elements? I think anytime a defendant takes the stand, that becomes the single most important part of a case. That is huge. If the defendant actually takes the stand, then the jury focuses in so much on what they have to say and how they say it and who they are and what their answers are. It's critically important. So I believe Donna Adelson will. We got 2 indications early on in the most recent hearings, 2 statements from her lawyer that she would be testifying. It's not required. She could change her mind. She could not testify at all, but we heard twice from her attorney that she would be testifying. So I think that will be, it always is unbelievably important. But the other thing I think in this case, there are 6 witnesses who are so important. 5 witnesses, if you don't count Donna, but Charlie and Wendi, her children, what they have to say, unbelievably important. Wendi will testify, although not on her mother's behalf. We did a video on that. She will testify for the state. And Charlie is in town. We don't know what Charlie will do. Will he take the stand and take the fifth, say my appeal is pending? Will he talk? We don't know. And there may be testimony from Donna Adelson's other child, Robert, her estranged son. We don't know what Robert will say. He's been deposed, but we haven't been given access to what his deposition said. So we'll have to wait and find out what that is. And then there is Katie Medbanowa, Charlie's girlfriend, plus the 2 hitmen that were hired by Katie Medbanowa. All of them have been convicted. All of them are serving life sentences. Well, except for Luis Rivera. He's one of the hitmen, and he got a lesser sentence. He turned state's evidence against Sigfredo Garcia. They will all testify. Obviously, since they say, at least, well, I don't know if Sigfredo will testify. He did not testify in Charlie's trial, but Luis Rivera and Katie Medbanowa both did. And I think what they have to say will be extremely important, extremely. All right, let's see where we are. This from Idiot Win. I've always thought good jurors for her would be people with meddling, overbearing moms. Somebody like Wendi said, well, yes, my mom, she didn't say meddling, overbearing. I've forgotten the exact word she used, but it was pretty much in that vicinity. Very overly protective. That's what she said. She stopped short of saying controlling. She went with overly protective. Jurors who probably think, yeah, I can see my mother saying those things. My mother would never commit murder, and take the punch out of some of that. So I think that You have a really good point, Idiot Wind. Now, what she wants is people who don't know about her case, people who have no opinion about her, people who are not from Tallahassee. She has no option there because they're all going to be from Tallahassee. But I think you're absolutely right. I think people who have similar life experiences. Now, there's always the risk that someone with a similar life experience will judge the person more harshly. It can be kind of a dance to figure out where exactly they fall on that continuum. All right, so let's head over and I'll have to back up a ways and see if I can find some of the question marks. But hopefully people have put at the beginning of the question so that I have a better shot at finding them. Oh, I see Marlon's message to people saying, put your questions in. So, okay, it'll be after that. Okay, Annie K is asking, if Charlie takes the stand and pleads the fifth, how could either side's attorneys explain that to the jurors since it will affect Donna Adelson's case? So I think it's not really possible to fully explain that, right? You can't really explain that away. The state would like that. That would be totally fine for them if they say, isn't it true you were involved? I take the fifth. Isn't it true that, and go through a list of things. Isn't it true that you were dating Katie Medvanova? Maybe, and if he takes a blanket Fifth Amendment to every question, then I think that could be a real problem for Donna. And it's very possible it would happen that he would feel like he needs to do that. The issue is this: he testified in his trial. So as to, and this is super complicated, by the way. It's not like every lawyer's like, oh yeah, well, of course, this is what happens. It's not. I tried taking a look through some of the issues and researched a little bit, and it looked to me like the rulings were that it depends on, it is limited to the proceeding in which you testified. So in other words, Charlie could not take the fifth in his trial and he's waived it at that point for purposes of that trial, but he can reassert it in Donna's trial. That's what it looked to me like the law was. That was a surprise to me. I thought it would be blanket, once you take it, it's waived forever. That was not what I was seeing in the case law I was looking at. Is that the final ruling? Absolutely not. Somebody would need to do hours and hours to make sure that's absolutely correct. But that's what it looked to me like the rule was going to be. So now, of course, gotten excited and lost completely what the question I was answering. Okay, it was Annie's question about if he takes a stand and pleads the fifth, how do you explain that? You don't explain it. It's the judge would make probably an instruction to the jury that says, every person has the right to take the fifth, and you may not speculate in any way about why they did that. That's almost surely what would happen, but nobody's going to explain it per se. Now, in closing argument, will they feel like they have to touch on that? Maybe, but it's not going to be other than the judge saying ignore that. It's irrelevant. That's probably the only way it would get addressed at trial. So if he does take the stand, I really think he might go ahead and testify. I mean, he did very well in his testimony at the first trial. By very well, I mean this. He was fully prepared. He did not trip up and did not contradict his story. The jury didn't buy his story. So if by did really well, you mean persuaded the jury, he did not do well. If by did really well, you mean hewed consistently to exactly what he thought what he came in there to say, he did that. Now, he hasn't been prepared for more than a year. So could he have lost some of that? Yeah, maybe. But I don't know. I think he possibly would testify on behalf of his mother as he did at the first trial, if that fits with what she wants to argue. I am really wondering what exactly she plans to argue. What will be her case at trial? We were surprised by Charlie's. It was not something anyone, including the prosecution, expected in advance. It just popped out and everybody was very surprised. There were some hints about it as we had gone through jury selection last time, but we will see what exactly happens. Okay. Carmina, when I think about the difference of jury mates, I remember your story. Oh my goodness, yes. I'll go ahead and tell that story again. Thank you, Carmina. I had the most unbelievable experience in law school. It was like an exact example of how much of an impact the jury makes. This is the archetypal example. So I'm a third-year law student. and I'm about to become a lawyer, and you do something in your third year that is really exciting. You have a mock trial. So you get to dress up in your suit and go down to the actual courthouse where there's an actual judge, and you get to have a jury of high school students to make it all real. And you are the lawyer. You get to play lawyer. And the way they do it is you have students who read they have a little excerpt they read, and then they answer questions during your examination. Other law students are playing the witnesses. In our case, we actually had a criminal case. And so we had a criminal defendant who was some poor law student who got forced to be the criminal defendant. And so we had, in our case, where we have, and may I say, you prepare for this like it is a Supreme Court argument. It was weeks of preparation. They brought in local lawyers to help us. So we had a mentor who helped us prepare, and you get your objections ready, and you're ready you just are totally ready. And it's so exciting. It was freezing cold winter's day in Boston. I went to Harvard for law school. And so maybe it was for March, but to me, that was high winter in Boston. And so I'm in my pumps and my little skirt, trudging through the snow in Boston to the courthouse. And this is just a huge red letter banner day. We are there at the courthouse, and there is one high school civics class seated in the jury box and spilling over because it's more than 12 people. When all of a sudden, in the back of the courtroom, another entire set of high school civics students files in with their teachers. And there's this huge confusion for a while. And the judge said, apparently somebody just accidentally sent 2 high school civics classes to our courtroom. And the judge tried to find them another place, and he told them, oh, you can just go. We don't need you. And they said, well, the bus has gone to take the elementary school students, so we can't do that. We can't just leave. And therefore, what we are going to be, we can wander around the courthouse, or we can sit here, your choice, judge. And very wisely, the judge said, oh, no, we will definitely keep you here. Not thinking about this. They're all hearing the case like they're jurors, but he did not think through the fact that his jury room was not going to be big enough to hold 2 entire civics classes. So we reached the end of our hard-fought trial, and he sends them one class, the second class, down to another judge's jury room. So there'll be enough room for them. So they deliberated completely separately. We have now reached the end of our trial. We wait for the jury a little bit, and the judge calls them back in. It's now time for the buses. And the jury foreman from one high school stands up and says, we, the jury, find the defendant guilty. So this was huge for me because I was the prosecutor. So I had won my first case, right? Absolutely enormous red letter moment for me. And so everyone in their minds, it's over, right? And everybody's talking, our mentor lawyer's talking to us. We're all talking about the case. And I'm thinking, oh, this bodes so well for my future as a lawyer. And then suddenly, seated in the front rows, one of the high school students stands up, Judge, yes? He said, we have a verdict too. And the judge's like, oh, well, okay then. What is your verdict? And the juror says, we, the jury, find the defendant not guilty. I was like, oh, dang it. I lost my first case in addition to winning my first case. So I don't know if that was a good omen or a bad omen or just there you have it. It was real life. But this was stunning to the courtroom. I mean, everyone is just in shock, but no one knows what to think about this. These 2 juries, these 2 high school civics classes, heard the exact same trial. They sat there in the same courtroom, watching the same lawyers make the same arguments with the same witnesses who said the same things. And they came to different conclusions. One guilty and one not guilty. That's as different as you get. And so the fact of the matter is, the jurors are so important in a case. That is one of the things I learned that day. It matters who your jury is. It matters who will be making that decision. There were a lot of other things I learned that day. one of which is mediation, and resolving cases without trial can be a very beneficial thing. There can be a lot of reasons for that. But thank you so much for reminding me of that, Carmina. It's a perfect story for this exact trial and for this moment in time. Thank you. Brandon asking me, is Donna allowed to give cookies to the jury that she bought from the commissary? I would suspect not. I am guessing there will be absolutely no trading of any goodies back and forth. So I would say no on that. Jane is asking about closed captions for hard of hearing. Jane, and I completely agree with you. I watch the closed captions all the time. The way it works with YouTube is for like court TV or law and crime, they'll be translating. You can just be a few minutes behind and they'll already have the captions up. But they won't do that for my video until they fully process the video, which is usually about maybe 45 minutes after our live stream ends. And then YouTube adds the closed captions. It's fully allowed. And you will find once it's processed, you will be able to do that. And I'm so sorry it can't be done in the live, but I wish it could. I'm with you as well. Janet, thank you. I'm so glad that you're looking forward to the live stream. Y'all really need to come tomorrow. I'm counting on y'all to be there so we can watch the trial together. I want your comments. I want to know what you think. I've never gotten to watch a trial with somebody before, so this is going to be really exciting to see what you think about it and what your ideas are, how the evidence is affecting you. I'm so curious what you will think about it and what will be important to you. All right, I'm looking for some final questions. Do you think Charlie will take the fifth? Sky Goddess 87 asks. That is such a good question. I cannot figure it out. I would certainly take the fifth. If I were Charlie, I would have taken the fifth in my trial, although he could not ever have made the argument he made by taking the fifth, because it was a really specific argument that no one else had the information about. So I admit he could not have had his defense without taking the stand. But if I were his attorney, I would be telling him, absolutely not. You may not take the stand because your appeal is pending and you might contradict something you said in the first trial. I might end up having a problem on appeal that you created by what you said here, or even worse, I might win for you. You get a new trial and you've said something crazy and then that torpedoes your second trial. So either way, I would be telling him, no, do not take the stand, do not testify. So I am very, very curious. Julia wants to know how I dress when trying a case. I have tried the pastel colors that my friend was told by the jury consultant. So that was sort of me. Plus, after I never had the dark suit. I don't know. I just wasn't a dark suit person. I mean, I have a couple, but mostly I have more, me, I really like color. I'm a big color person. So I tend to have colored suits like blue or pink. That was one of my favorites ever. Was a pink suit. It was really nice. It was a few years back, quite a few years back. Annie K, sorry, I've already answered Annie K's question, I think. Brandon is still on the cookies issue and wants to know about bringing an oven in the courtroom, imbibing the scent. No. However, I do think we're going to have another cooking contest, because remember that Donna Adelson made, what was it? Yeah, somebody in the chat will put this in. What was it that Donna Adelson made that supposedly for Dan Markel? And I'm going to go all the way down to the bottom so I'm so far behind on the questions anyway, I will never catch up on that. But what is it that she made for him? And Wendi's statement was, yeah, although Dan filed this motion asking that my mother, banana bread. Thank you to all of the people who put banana bread in. Thank you. Yes. Wendi said, although he filed this motion that my mother not be allowed unsupervised visitation with our children, my children with Dan Markel, he didn't really mean it. I mean, they were really good friends and he asked her to babysit for him and she made him banana bread and it's all good. And there was no animosity between them. So I don't know. I'm thinking we may need a banana bread recipe contest. We had during the Lori Valadabel trial, the green chili chicken enchilada recipe. So I'm thinking we may need to do a banana bread one for this time around. All right. Well, I will be looking forward to tomorrow. Please come for our first ever on the channel live stream of a trial. I need you there. I'm really curious what you think about the trial. So please spread the word too. Let people know that we're going to be doing that. We'll be going live tomorrow when opening statements start. We'll do it before opening statements start, but we will be live, and I am counting on you, and I'm counting on your questions too, and what you are thinking about. And we'll do some polls and try to figure out where you are. I'm super curious. All right. So we will, don't forget, I'm going to be over on Courtroom Confidential in just a little bit. So head on over to that particular channel, and we're going to be talking more Donna Adelson. So we'll look forward to seeing you there really soon. And now I have to figure out how to put this into this happened to me last time. I have this thing here. There was some trick to it. Oh, I know where it was.